Hello everyone, I'm Debojit Das and this is Courts Today by Live Law, your essential daily roundup of everything that is law. The breeze seems to be cooling down despite of all the smoke in the air, but courts across the country were busy as ever. So let's get right into it. Beginning our segment with what seems like essential ground in a win for procedural rights under the UAPA, India's stringent anti-terror law. The Supreme Court, through a bench of Justices M.M. Sundaresh and Vipul Pancholi, quashed the arrest and remand of three individuals, including a leader of the Hizb ut-Tahrir organization, booked under sections 13 and 18 of the UAPA. The court held that the mandatory requirement of furnishing written grounds of arrest was not complied with. Critically, it rejected the NIA's argument, which the Madras High Court had accepted, that the remand court explaining the grounds or providing a remand requisition report was sufficient compliance with the mandate of section 43B subsection 1 of UAPA. Relying firmly on precedents like Pankaj Bansal versus Union of India, the Apex Court established that an explanation by the jurisdictional court can never be an adequate compliance. The arrest and remand were set aside solely on this procedural flaw, reinforcing the inviolable right to be informed of the grounds of arrest in writing. Next, in an important development, the Government of India has proposed critical amendments to the IT Rules 2021 aimed squarely at combating deepfakes and misinformation generated by AI. The draft rules introduce the term synthetically generated information, content artificially created or altered to appear authentic, and impose mandatory labeling requirements. Intermediaries that provide AI creation tools must clearly label all synthetic content or embed non-removable metadata. Specifically, visual labels must cover at least 10% of the display surface, and audio declarations must last for at least 10% of the duration. Furthermore, significant social media intermediaries like Meta and YouTube must obtain a declaration from users at the time of upload, confirming whether the content is synthetically generated, and use automated tools to verify these claims, enhancing platform accountability. Turning our attention to a firm directive from the Supreme Court. Here, the case involves the 2019 murder of Vijendra Singh, where the victim's son challenged the Delhi High Court's bail order for an accused, Raj Sharma, alleging that the many prosecution witnesses turned hostile after other accused were released. A bench of Justice Ehsanuddin Amanullah and Justice N.V. Anjaria noted the intimidation claims. While directing the state to provide police protection for the remaining official witnesses, the judges issued a sharp warning to the trial court. It is made clear that if the trial court finds that any witness has tried to take sides in their deposition without being truthful to the court shall take suo motu cognizance of such conduct and initiate action in their individual capacity. The ruling essentially empowers the trial judge to crack down on perjury and ensure that the sanctity of evidence is maintained without waiting for a formal complaint from the prosecution. Next, in an ongoing heart-wrenching matter, the Orissa High Court has rejected the bail pleas of the principal and HOD of the Fakir Mohan Autonomous College, Balasore, in the tragic student self-immolation case. The case stems from the death of an undergraduate female student who set herself ablaze on campus in July, succumbing to injuries 2 days later. She took the extreme step after allegedly facing repeated sexual and mental harassment from the HOD, Samira Kumar Sahu. Crucially, the student had flagged the harassment to the principal, Dilip Kumar Ghosh, but her grievance was allegedly sidelined, and an internal complaints committee found no merit in her complaint either. Justice Aditya Kumar Mohapatra held that the inaction of the college authorities was the sole reason for the deceased taking the extra step, a failure that shocked the conscience of the people of the state. The court, however, granted bail to two student co-accused due to lack of incriminating evidence against them. Moving on to the Kerala High Court, as it delivered a significant ruling against caste-based exclusion in temple priesthood. The Akhil Kerala Tantri Samaj challenged the Devasam Board's rules, arguing that requiring certificates from accredited Tantra Vidyalayas diluted centuries-old customs and that adherence to specific caste and lineage was an essential religious practice protected by the Constitution under Articles 25 and 26. However, the division bench of Justice Raja Vijayaraghavan and Justice K.V. Jayakumar firmly dismissed the petition. The court held that being a priest is not an ERP or essential religious practice that mandates caste or lineage. It affirmed the board's statutory authority to regulate appointments based on competence, rigorous training, and merit-based selection, asserting that caste restrictions for eligibility cannot be constitutionally justified. Shifting our focus back to Delhi, where in a noteworthy decision providing relief against the harsh application of UAPA, the Delhi High Court affirmed that the right to life under Article 21 of the Constitution encompasses an individual's right to fulfill religious and personal obligations. The case involved Shahid Nasir, the PFI Karnataka unit treasurer, facing severe UAPA charges, including conspiracy and channelizing funds for unlawful or terrorist activities. Nasir sought temporary custody parole to observe the Fatiha ceremony for his late mother-in-law, arguing this was protected under Articles 21 and 25. Despite the NIA's objections regarding the gravity of the allegations, Justice Ravinder Dudeja granted the 2-day parole. The judge held that denying an under-trial this religious duty would constitute an unreasonable restrictions on human dignity, emphasizing that a prisoner retains the protection of fundamental rights even under the restrictive grasp of the UAPA. Next, an important development surrounding BSNL coming in from the Karnataka High Court. The current domination of market leaders like Jio and Airtel starkly contrasts with the reality exposed by BSNL's persistence that vast portions of India remain a developing economy where a lack of affordable and accessible internet highlights enduring societal divides. This reality forced residents of Bhavani Bijalgaon village in Bidar who endure zero mobile connectivity to seek judicial intervention. The Karnataka High Court, through Chief Justice Vibhu Bakru and Justice C.M. Punacha, ordered BSNL to immediately consider their tower installation plea, emphasizing that connectivity is crucial for accessing government services. This struggle echoes the reported 8-year battle of Varambali village, which could not secure a tower even after escalating requests to the Prime Minister's office. These local fights for basic digital inclusion coincide with BSNL's surprising market resurgence. The state-run firm reportedly added 1.4 million mobile users in August 2025, eclipsing Airtel's 500,000. Amidst commercial players' escalating costs, BSNL's growth in rural markets suggests it is uniquely positioned to address the necessity for cheap coverage, a need robustly endorsed by the High Court's directive. And for our final headline, we'll take a look at the Kerala High Court, which delivered a ruling on judicial procedure, clarifying that an accused exempted from personal appearance can answer questions under Section 351 of the BNSS either through a written statement or via virtual linkage. Justice C.S. Diaz passed this order in the case of an accused facing trial under Section 55 Clause G of the Kerala Abkari Act and employed abroad, whose plea to have his counsel answer on his behalf was rejected by the trial court. The High Court relied on Section 351 subsection 5 of the BNSS, which permits a written statement as compliance, and the Supreme Court's Basavaraj R. Patil judgment, which allows dispensing with physical presence in cases of genuine hardship. The ruling further cited Kerala's new electronic video linkage rules and Section 251 subsection 2 of BNSS, which permits reading charges via video, concluding that technology integration ensures accessibility to justice. And that's a wrap for us at Courts Today. Remember to keep yourself updated with every story mentioned here and much more. Visit www.livelaw.in and follow all our socials to stay updated with issues that matter.